Hey out there, legal warriors. In this video, I'm going to cover one of the most common misperceptions that cause people accused of crimes so much trouble. It's when do the police have to actually read you your rights? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. I've been a defense attorney, for 25 years. Prosecuted for many years before that, and trying to think, what does the public need to know? And, if we get accused of a crime, we're usually pretty upset, right? And we're thinking about what we saw on TV. And so many times I hear this mistake from someone coming in, well, they didn't read me my rights. The officer didn't read me my rights, so the case has to go away, right? Because we all know if an officer talks to us, they got to read us our rights. And what do we mean by our rights? Miranda warnings, right? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, we'll appoint one for you prior to questioning. And if you start answering questions, you can stop answering those questions at any time. So they got to read us our rights. And if they don't, hey, we're mad, we're upset, the cop did it wrong. Well, for the most part, when someone thinks that, it's not the cop who did it wrong, it's the person thinking that who has it wrong. So in Washington State, and through most states, because it's a national law, Miranda it's a U.S. Supreme Court type issue, Miranda only applies to custodial interrogation. Custodial interrogation. So, in determining whether or not an officer is required to read Miranda warnings, the court's going to look at, one, was the suspect in custody, and two, was that interrogation that the officer was doing. So let's start with custody. Now, we can get into the comments. I'm not going to get into deep nuances of case law because, as we all know, case law is bogus. It's just made up stuff that's, outcome oriented. In a murder case, case law is going to really go against the guy accused of murder, as if someone is has a lot of fancy lawyers and is less serious, some of that case law might turn out a little better for them, right? So, but it's still the game that we have to play by. So, but in general, to be in custody generally means that the suspect's, freedom of movement is constrained to something similar to formal arrest. So think about handcuffs, right? If you're handcuffed, it doesn't automatically mean you're in custody, but it's more likely that you can make a very strong argument, hey, I wasn't free to leave, I was handcuffed, I was arrested. And there's lots of different case law out there how we can argue custody. How much was there a show of force, right? If 6 cops showed up with machine guns and pointed them at us, we might not be handcuffed, but we're probably in custody at that point, right? And so it varies. It's fact by fact, case by case. But what it's not is an officer just walks up to you to the street and starts to talk to you. You're not in custody. Therefore, that first prong that requires Miranda does not apply. In fact, the officers will say, look, I was just investigating. So all these questions before someone is in custody, they don't require Miranda, right? They're just investigating. And, we can, again, pull out your case law, do whatever you want, but that's how you need to think about it when you're thinking about the situation. So if you want to make an argument that, hey, I should have been read Miranda, think about why it is you felt in custody. Why is it you didn't feel free to leave? How did the officer treat you, right? A great argument is you pull into the gas station, you're sitting there now, some cop doesn't like the looks of you, they come and they lock your car in, right? They lock your car in so you can't back out. Pretty good argument you're in custody at that point. No way you could leave. You're not leaving without your car, right? Arguments can be made if they take your ID. They take your ID and they never give it back, right? So were we free to leave because we're not leaving without our ID? So, it's going to vary, but it's sort of imagine building bricks where you're trying to get the decider, the judge, to determine that, Miranda was necessary, because there is no absolute truth. There is no absolute black and white law. It's whatever the decider, the judge, decides in your particular case. And that judge, may be really mad at the cops, and they may be not like the cops, but usually the judges like the cops, right? Because they've got to get reelected, and it's tough for a judge to tell law enforcement you did something wrong. So that's prong one. What's prong two? Well, interrogation. So just because if you happen to literally be in custody and you're handcuffed and you're in the back of the car and you start to blurt out, oh, by the way, yeah, I did kill the SOP. I killed him, I stabbed him 4 times and he deserved it. Well, you might think, hey, in this scenario, I was never read Miranda. I'm in custody, so that must be in my favor. It's not in your favor, because interrogation means that the officer has to ask a question designed to produce an incriminating statement or result. In other words, something against you. Incriminating means they're trying to get you to say something that they can use to show you're guilty later. So if you happen to be in custody and the officer says, hey, what's your favorite bowling alley? Well, that's not interrogation where it's designed to show you're guilty of something, unless you're accused of knocking off a bowling alley, maybe it is. So if you're driving around after you're being handcuffed, you're just standing around and you blurt something out prior to Miranda, it's not going to get suppressed because it wasn't interrogation. So an officer, example of interrogation would be you're already arrested, they handcuff you, they're getting ready to put you in the car, and the officer says, at the last second, hey, did you have 4 shots or 3 shots? And you go, I had 4 shots. Well, on a DUI investigation, that statement would likely be required to have Miranda before it, because you're hopefully we can argue you're in custody, you're all handcuffed, being put in the car, and they're asking you a question about what you drank on a DUI arrest. But so what's the third thing? What's the remedy? What if they did screw it up? Does my case go away? Is it dismissed? It's not dismissed if the Miranda rules are violated, unless there's no evidence left after they suppress the statements. So if there's a violation of Miranda rules, that you were in custody and you're subject to interrogation without Miranda, the remedy isn't you win. The remedy is any statements or evidence that comes out of those illegally obtained confessions that were in custody without Miranda, that evidence gets suppressed. So that might mean one statement is out, 2 statements is out, maybe your whole confession is out, but that doesn't necessarily mean the government can't proceed if they have other evidence that they can use besides those statements. So in each and every case in Washington State, there's a 3.5, Rule 3.5 hearing required, where the state is asked, are you planning to use custodial statements of the defendant in your case in chief? And if they are, then the defense gets the right to have a 3.5 hearing to determine whether or not those statements are admissible in evidence. And oftentimes, learned counsel sort of know what looks right or not. The prosecutor might go, yeah, that one's out, and the defense go, yeah, that one's in. But if they don't agree, there is a hearing where that can be fought about ahead of time. So what have we learned? We've learned that, hey, they hardly ever need to give Miranda. There's so many ways around it. And if they forget to give Miranda, the remedy is going to be suppression of custodial statements, not a get-out-of-jail-free card. So still important to know, we still need to build our case, but it is a big myth that gets people in trouble because they think they've got some big win on their hands, and they get pretty unhappy when they realize that, hey, guess what? Case law is stacked against people accused of crimes. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.